So don't forget to like and to subscribe. So yeah, guys, today we'll be dealing with the beginning of legal personality and child. I'm so sorry that I couldn't include the second aspect of it, which is, the second part of it, which is the end of legal personality. So oh yeah, reason being is that I wanted to make this video so short. So yeah, let's get to the business of the day, guys. So what you guys need to know is that when does legal personality begin and the requirements pertaining to legal personality. And then after that, we will indulge in the aspect that I've written on the screen, as you guys can see. So now, guys, you all know that a natural person's legal personality, it begins at birth, provided that the stillborn meets what certain requirements that are restricted, whereby those requirements are in instances such as what stillborn's body being separate from the mother's body, whereby birth is fully completed, and also in instances whereby the child lives for a specific short of time. So once those requirements have been established, that will automatically renders what legal personality coming into place, meaning that the person has acquired what rights, duties, and duties, which could enable you into entering, be it contract or anything. You understand me? So that therefore means that failure for you to actually satisfy those requirements will automatically mean that legal personality never existed. It never came into place, meaning that you don't have rights and duties. You understand me? So those are the requirements. Then after that, we're going to go to the registration of birth, because once the legal personality have been established, what will happen is that both of your parents will go to the director general and notify him about the birth. And then what the director general will do is that the director general will issue documents, provided that accompany your documents that you're going to give notice of with affidavit, certificates, and all those kind of things. Thereafter, you get a certificate which will belong to the child, and the child will actually take over the surname of the mother. So what we see here is that we come into So we get to see a case of J versus Director General of Department of Home Affairs. So I've written it on the case. So meaning that every time when you guys read registration of birth, take into cognize that there is a case. So what transpired in this case is that a woman in the same-sex life partner gave birth to twins, whereby these twins, they were given birth by artificial fertilization, right? Whereby the problem was whether these twins had to be registered as what? Had to be registered as the birth mother or the woman in parent, because we do notice that in accordance of the Registration Birth Act, it was said as to that once notice is given, the child is going to take over the surname of the mother who has birthed him or her. You understand me? So this case was problematic because we get to see same-sex life partners giving birth through artificial fertilization. Now we don't know as to is the child either gonna take one of the mother's surname, or is the child going to use both barrel surnames? You understand me? So what the court did is that the court concluded as to say that now children born through artificial fertilization of women of the same-sex life partnership, they are registered to either they are eligible to carry either one of the mother's surname or one of or both barrels. You understand me? So that is the case pertaining to the registration of birth, right? So now we're going to go to the protection of interest of the unborn child. So with regards to the protection of the interest of the unborn child, we know that a natural person's legal personality, it begins at birth, right? Meaning that obviously failure for you to meet failure for you to be identified as a legal personalities rendered you not having any rights, duties, or anything. Ne? So therefore an unborn child does not have those right duties, because legal personality have never been acquired by that person, because the person is still unborn. But then we do notice that our law tries to accommodate the unborn, the stillborn kids, right? By doing by making an application with an Nasciturus fiction in order to accommodate and to promote the interest of the unborn, right? So what happens is that the Nasciturus fiction is aimed at promoting the interest and promoting unborn in order for them to do what? To have claimants. You understand me? So an example that I can give is instances where A and B are actually married, whereby A is pregnant, then prior to A being pregnant leads to B dying. Then B is the testator, if you can remember. So what happens is that prior to the death, the fact that A was pregnant while B was alive, it automatically means what? It automatically that the child has what? Has a claimant in terms of Nasciturus fiction, because what? The father died while the child was what? Was conceived. So that is it about Nasciturus fiction. It enables and implements the interest of the child in order to do what? To have claimants for the fact that you were conceived while the testator was still what? Was alive. So you do know as to that there are certain requirements that you must meet in order to be identified as a what? And as an Nasciturus fiction, and be awarded those what? And be awarded those rights to do what? To claim, such as a what? Obviously, you should have been conceived by the time the testator died. You understand me? And the other thing is that you should be born alive, because obviously you cannot have a claim, once you are not born alive, because we always know that only legal personalities can claim, right? I mean, legal people can claim, and those people are what? Are people who are born alive and acquired what? Rights and duties. So that is it about what? About Nasciturus fiction. And period to Nasciturus fiction, it is also important for you guys to know the fields and application of Nasciturus fiction, right? Whereby the fields of an application of Nasciturus fiction, there are many in broad, such as succession and be it dependent action for loss and prenatal injuries, right? So we're going to start with succession. So period to coming to succession, we know that we have two types of successions in SA. Be it what? Interstate succession, meaning that the testator didn't leave a valid will or didn't write a will at all, and also what? Testate succession. So with regard to application of succession in terms of interstate succession, these are instances whereby let's say the testator died and the testator just died without leaving a will, whereas all his property and assets need to be distributed amongst the kid. So the kid being the what? The kid being the unborn child, who is the what? Who is the Nasciturus. That specific Nasciturus is going to benefit, because we're going to do what? Because the law accommodates the Nasciturus by doing what? By applying this fiction in order for that Nasciturus to have a claimant. You understand me? So it promotes your right so that you can have a claimant and benefit. You understand me? So but then this becomes problematic in terms of testate succession, because we notice that in terms of testate succession, right? So the testator can die and state as to, I leave my assets to A and B, and obviously the unborn is not A and B. You understand me? So only the ones that are mentioned in the will are eligible to do what? To benefit, meaning that the unborn cannot benefit, right? Yes, but then can therefore apply for maintenance towards the deceased estate ever since he's the father, something like that. You understand me? So that is it about the what? About application of Nasciturus in terms of succession. And we also have a case such as ex parte Steenkamp, and this is just an easy case, and I believe you know it. It's just like the example that I gave right now. So then the other application, it's dependent action for loss and support, right? So now with dependent action for loss and support, what happens is that with this regard, we have a case called Chisholm versus Israel Property Mines, whereby it emphasized upon defendant action of loss and support and held that a child whose father dies prior to the death of someone, that child actually can claim damages from that specific person who killed what? Who killed the testator, who is the what? Who is the father. So you as the unborn, once you are alive and acquired legal personality, you can claim, or maybe your parent actually, they can claim for you through Nasciturus fiction in representation of the what? Of your father. Because if happen your father was alive, you are gonna have what? You are gonna have support. But then now that your father has died due to someone's negligence or something, the same person who killed your father can now do what? Support you for the damages and the loss that has occurred to you. You understand me? So that is also an important case. So be ensure that, so be reminded that we dealt about the expert of Wardell case, the Chislom case, and also the case of J versus Director of Home Affairs, meaning that be it a question in exam, you'll be able to answer this. You understand me? So we also have aspect pertaining to prenatal injury. So in instances of prenatal injury, this is instances whereby, let's say, A is pregnant, and then being pregnant, A gets in an accident, you understand me, whereby the child is inflicted or something, right? So with regards to prenatal injury, the woman being infected during pregnancy, the woman can claim compensation of that specific unborn if happened the inflictions were caused by the what? By the accident, provided that you prove beyond reasonable doubt as to the inflicting that has acquired towards my child were caused by the what? They were caused by the what? The person who has caused negligence. But then if you fail to prove, well, you're not going to benefit in terms of Nasciturus, or you're not going to rely on it anyway, you understand me? And then now we're going to aspect pertaining to termination of pregnancy, which is just an easy one. So this has nothing to do with Nasciturus, because we know that the Nasciturus, it promotes the interest of the unborn. But then with termination of pregnancy, we cannot promote the interest of unborn, because in here the interests are not taken into consideration, because in termination, we kill the fetus, right? Meaning we haven't even promoted any interest at all. So the only thing you should know is that you should know the act, which is the Termination of Pregnancy Act, and you should know the circumstances in which pregnancy may terminate. They give circumstances as to that. Obviously, you cannot terminate once you are 15 weeks. That's impossible. So this act specifically gives you a guideline on certain aspect pertaining to ways in which you can do what you can terminate. And then you need to know that in termination there has to be consent. You understand me? And failure for that consent will do what will mean that you won't be allowed to do what to terminate. But then there are certain exceptions to that, whereby some of the exceptions they were healed in the case of Christian versus Lawyers Associations of the one that I've mentioned here. So that's it, guys, for now. So now let's go deal with the question and see if whether we're able to capture everything that we have dealt with and taking into cognizance. Don't forget that the cases that we refer to, I'll just include them in the comment sections so that you guys can remember them. But then you do know them ever since you're using textbooks. You understand me? So now with regards to questions, yes. So in this question, it says Ms. Smith, an expectant mother, was injured in a motor vehicle accident. Her child was subsequently born with cerebral palsy. So by just looking at that statement, certain aspects have to capture your mind, which is what you get to see that injuries were caused by motor vehicle, which automatically takes you to what? Nasciturus fiction, because we get to see expected mother, meaning an unborn, sufficed in this scenario, which is Nasciturus fiction. Injuries inflicted, which automatically tells you we're going to focus on what? Prenatal injuries, which automatically also tells you that we're going to include the case that I told you about, which is I forgot what they call it, the case, but then so So no, wait, I remember the case is Pinch versus Centum. You understand me? So let's read the first thingy. What do you understand by Nasciturus fiction? You just state as to what is Nasciturus fiction, the requirement, right? So so name two requirements. So that is it. So can you describe Nasciturus fiction being applied in a case? That is the case, the Pinch versus Centum insurance case, whereby it spoke about a woman who has been inflicted, but then it was uncertain as to the child being injured.